Mr. Chairman, if I can make a quick announcement. Good afternoon, folks. Welcome to the BMZA. We have today the last hearing of our current chairman, Jeffrey Washington. He has served the board diligently for 10 years under the Dixon, Rawlings, Blake, and Pugh administrations. So we just want to thank him for his service. I'm sure he will continue to serve in other capacities, but this will be his last hearing with the board. And if we could just give him a brief round of applause.
Thank you very much. It's been an honor and a privilege to serve with all of my colleagues going back from our beginning of my service in April of 2008 through today. So, it's also been great to serve alongside of you, Derek, and as well as David before you, and Bob, you, and even going back to Lois. It's been great. And Jeff Beal, too. So, all right, not to belabor things, but let's get started. Good afternoon and welcome to the Tuesday, August 21st convening of the Board of Baltimore Board of Municipal and Zoning Appeals. A few housekeeping rules before we get started. First, if you have a cell phone, a pager, anything that makes any sort of electronically generated audible sound, anything that plays a ringtone, a chime, a beep, etc. We ask at a minimum that you turn those devices to a vibrate only, if not off position. And similarly, to the extent that you need to have that you'd like to have a conversation with someone, we ask you to please take those conversations to the double doors to your rear. And the reason for those rules is pretty simple and straightforward. There are a number of microphones which are arrayed around us up here, and those microphones are all very sensitive, not only for the purpose of amplification, but also for the purpose of recording. And cell phones, pagers, conversations, and the like disrupt not just the general conduct of these proceedings, but also the recording of these proceedings as well. In addition, those of you who are sitting forward of the wall above you, if you turn around, you'll see that there are 1, 2, 3 video cameras which are mounted on the wall up there behind you, and there are 1, 2 video cameras which are mounted on the wall up here behind us. And these proceedings are being streamed live on the city's cable access, well, the website for the city's cable access network, as well as videoed for tape delay broadcast on the cable access network and stored for all posterity on the city's YouTube channel. So cell phones, pagers, conversations, and the like also interrupt that video recording and streaming process as well. We will be voting at the end of the day, and you're certainly more than welcome to hang around and enjoy a civics lesson if you so choose. But if you've got other things to do on this late August afternoon, we can certainly understand that. If you call into the zoning board office in the morning, I'll read that number off a couple of times, you'll be able to find out how we ruled in your case. That number for the zoning board office is 410-396-4301. That number again is 410-396-4301. You will, however, need to wait until you receive the formal written notice for the outcome of your case, which should be forthcoming in about 3 to 4 weeks, before you'll be able to get your permit. We certainly ask that you please not begin any building activities in the city of Baltimore without first obtaining all of your proper permits. If you haven't already done so, if you're here in opposition to any case today, we ask that you please sign in on our signing sheet, which is being held up there by Mr. French. Signing sheet allows us generally to know which cases have opposition, as well as allows us to know who needs to receive those aforementioned written notices I was just talking about. We do have some cases which are being postponed, one case which is being withdrawn. In order to know who you are and to let you know when those postponed cases will be going forward, we need to know who you are and how to contact you to let you know when those hearings will be. So again, please, if you are here in opposition to any case, just make sure that you signed in on our signing sheet. The procedure for today is the same as it is all of our hearing days, and those of you who are unfamiliar with it, I will go over those briefly with you. When the cases are called, you'll come forward. The appellant will stand to our left or your right. The opposition, if any, will stand to our right or your left. Once everyone's up here, we'll get you all sworn in, and then we'll first begin with the applicant, who will be given the opportunity to tell us about what it is they're proposing, present any documents, witnesses, et cetera, any other evidence that they would like to present in support of their request before the board. In addition, the board may have questions, and you can respond. You'll be responding to any questions the board might have and presenting any other witnesses which you would like to have testify in support of your appeal. Once the appellant has concluded, we'll then be turning to the opposition and be given the opportunity to do the same. That is, present their documents, witnesses, et cetera, that they would like to present in support of their opposition. Once the opposition is concluded, we'll go back to the appellant. We'll be given the opportunity to respond to any points that were brought up by the opposition, if any, and to give a closing statement. We won't be going back and forth, unnecessarily delaying things any longer than is necessary. We'll be generally hearing the cases in the order in which they appear on our docket after we first deal with some preliminary issues. First, we have a number of cases which are being postponed, beginning with 2018-46, which is 2000 McElderry Street, down to 2018-50, 2008 McElderry Street. These cases are all being postponed. So if you hear in reference to any of these cases, I don't think I saw anyone signed in on them, but if you're here in reference to any of those cases, we ask that you just make sure that you signed in on our signing sheet so that we know who you are, and so we can let you know when those will be going forward, as they will not be going forward today. Next, we have one case which has been withdrawn, 2018-20, which is the property known as 6100 through 6102 Holabird Avenue. That case has been withdrawn. There was one person I saw who had signed in on that, and you'll be good to know that we won't be going forward on that case because that appeal has been withdrawn. So those were it as far as postponements for today. Next are the cases on our consent agenda, and the consent agenda consists of cases, well, just a second. Who signed in on 2018-20, that's 200? Which is 6100 through 6102 Holabird Avenue? No? Okay. I guess they must have lied. Okay. All right. Next are the cases on our consent agenda. And the consent agenda consists of cases where the zoning board staff has reviewed the files in these matters, and the board has concluded that we have sufficient information to approve these appeals based on the record which has been submitted. I'm going to call all the consent cases together as a group, and we'll try to stay in the order in which you're called. Once everyone is up here, we'll get you all sworn in as a group, and then we'll call each case in turn. And then you'll be given the opportunity, once your case is called, to add any information that you would like to have added to the record at that time. First case on the consent agenda is 2018-225, 209 East Mount Royal Avenue, Frank Federico. We also have 2018-230, 207 East Mount Royal Avenue, which is also Frank Federico. After that, you'll come forward, sir. You'll just stand right there. Yeah. After that, we'll have 2018-238, 113 West Ostend Street. This is Nate Prettle. Then we'll have 2018-253, 210 through 212 McAllister Street, Rory Yee. 2018-258, 2200 East Biddle Street, Carlton Gilbert. 2018-260, 3221 Noble Street, Amalia Montgomery. And 2018-280, 551 through 553 South Packer Street, also Nate Prettle. Okay. If all those intending to give testimony in these matters will please raise their hand and be sworn.
Please raise your right hand, please. Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
All right, calling the first case, which is 2018-225, 209 East Mount Royal Avenue, Frank Federico. We'll call that together with case number 2018-230, 207 East Mount Royal Avenue, which is also Frank Federico. Good afternoon, sir. You Mr. Federico?
Actually, no, my name's Nick
Okay.
Liparini. I'm representing the owner.
Okay, can you spell your last name, sir?
Yeah, it's Liparini.
All right. And Mr. Liparini, we have, as to case number 2018-225, we have that as an appeal to construct a first-floor deck at that location. Is that correct?
Correct.
Okay. And as to appeal number 2018-230, which is 207 East Mount Royal Avenue, is similar, but a little bit different. The request is to construct first-floor rear decks onto portions known as 205 and 207 East Mount Royal Avenue. Is that correct?
Correct.
All right. Mr. French, anything for the planning department?
Thank you. Martin French for the Baltimore City Planning Department. These properties are located in the Mount Vernon Historic District, and that district controls certain exterior alterations to properties in that same area. The department therefore recommends approval of this application be subject to the condition that all exterior changes, including additions such as the proposed deck, demolitions, and alterations are completed in accordance with an authorization to proceed issued by the Commission for Historical and Architectural Preservation. Thank you.
Thank you. And Mr. Liparini, are those conditions stated by the planning department acceptable to you?
Yes.
All right. And is there anything further you'd like to have added to the record in these matters?
Nope.
Okay. Zoning board staff, having previously reviewed your applications, we have determined that there is sufficient information to approve your appeal.
Thank you.
Good luck to you. Next, 2018-238, 113 West Ostin Street, Nate Prettle.
Good afternoon.
Afternoon, Mr. Prettle. We have this as an application to construct second floor and rooftop decks at this location. Is that correct?
That is correct.
All right. Mr. French, anything for the planning department with respect to this appeal?
Planning Department has no comment on this application. Thank you.
Okay. And Mr. Prettle, anything further you'd like to add with respect to this appeal?
No.
Okay. Zoning board staff, having previously reviewed your application, we have determined that there is sufficient information to approve your appeal.
Thank you.
I'll call your other case, which is 2018-280, 551 through 553 South Packer Street. Mr. Prettle, we have this as an application to construct a three-story single-family row home with two-car parking pad and rooftop deck at this location. Is that correct?
That is correct.
All right. Mr. French, anything for the planning department with respect to this appeal?
Thank you. Yes, this property is located in the Ridgely's Delight Historic District, and the applicant has actually been in front of the Commission for Historical and Architectural Preservation in the past week to get approval of the designs. The department therefore recommends approval of the application, subject to the condition that the proposed dwelling structure is constructed and completed in accordance with plans and elevations approved by the Commission for Historical and Architectural Preservation and by CHAP staff, as specified in an authorization to proceed issued by CHAP. Thank you.
Thank you. Mr. Prettle, those conditions stated by the planning department acceptable to your client?
Yes, they are.
Okay. Anything further?
Just to reiterate, when Mr. French said that there was a CHAP hearing last week, which is actually the second CHAP hearing on the new design, and it was received final design approval, and which is basically what his comment was, and we fully intend to comply with that design approval.
Okay. Zoning board staff, having previously reviewed your application, we've determined that there is sufficient information to approve your appeal.
Great, thank you.
Good luck. Next up, 2018-253, 210 through 212 McAllister Street, Ruri.
Yes.
Afternoon, ma'am.
Good afternoon.
We have this as an application to use the first floor as an art gallery at this location. Is that correct?
Yeah, it's actually the home gallery, home art gallery. Yeah. So it's
Okay.
not kind of commercial. It's like
I'm sorry?
more. It's not commercial gallery. It's a home gallery
Okay.
because I'm living upstairs, living there. So
Okay, but the area where you're going to be, it's going to be a art gallery.
right.
Okay. Mr. French, anything for the planning department?
Planning Department has reviewed this application and recommends approval. Thank you.
Thank you. And Ms. E, anything further you would like to add to supplement the record with respect to this appeal?
No, actually, I was the inquiry for zoning office for the use and occupancy permit. but it's end up like this. So
Yeah, this is the first step, and then you'll be able to get to there. So hopefully we can send you on your way. Anything further?
no, that's it.
Okay.
yeah.
The zoning board staff, having previously reviewed your application, we have determined that there is sufficient information to approve your appeal.
Thank
luck
you.
to you.
Thanks.
Take care. Next up, 2018-258, 2200 East Biddle Street, Carlton Gilbert.
Yes, good afternoon.
Afternoon, Mr. Gilbert. We have this as an application to install a rooftop telecom facility consisting of 8 antennas, 1 dish, and equipment at this location. Is that correct?
That's correct.
All right. Mr. French, anything from the planning department with respect to this appeal?
Yes, the planning department has reviewed the application and recommends approval, subject to these conditions. The antennas and related equipment must be painted to match the building to ensure they are visually unobtrusive. Panel antennas and related equipment will remain mounted as illustrated in the plans and elevations submitted to and approved by the planning department. And the applicant will adequately mitigate any adverse effect as specified in the report of the Historical and Architectural Preservation Division of the Department of Planning in accordance with that report's recommendations. Thank you.
Thank you. And Mr. Gilbert, are those conditions stated by the planning department acceptable to you?
Yes, they are.
All right. And anything further you'd like to add to supplement the record in your case?
No, sir.
All right. Zoning board staff, having previously reviewed the application, we have determined that there is sufficient information to approve your appeal. Good luck.
All right, thank you.
2018-260, 3221 Noble Street, Amalia, Montgomery.
Yes.
Afternoon, ma'am.
Good afternoon.
You're Ms. Montgomery?
Yes.
Okay, and we have this as an application to use the premises for 6 dwelling units. Is that correct?
Yes.
Okay. Mr. French, anything from the planning department with respect to this appeal?
Planning department recommends approval of the application. Thank you.
Thank you. And Ms. Montgomery, anything you would like to add to supplement the record in your case? All right. Zoning board staff, having previously reviewed the application, we have determined that there is sufficient information to approve your appeal. Good luck.
Thank you.
Take care. All right. That concludes the consent agenda. Move on to the remainder of our docket, which will include cases where opposition is signed in. And frequently we found that opposition can be the result of either a lack of communication or miscommunication among the parties. And it can be useful to offer the parties an opportunity to have a dialogue with one another to see if they can resolve whatever differences they have. Obviously, if there are 2 sides who are engaged in a dispute, and those sides approach the board and ask the board to resolve their dispute, one of those 2 sides is bound to go away disappointed with the result. So this is your opportunity to avoid that unhappy fate. I'm going to read the cases off where we have opposition, which is signed in. I'll ask that you just stand where you are. You don't need to come up. But I'll ask if there has been communication among the parties and if the parties would like to either have a dialogue or continue their dialogue now. Certainly don't have to take the offer to speak with one another, but we do encourage and appreciate it. If the parties are inclined to speak, just step out the double doors to your rear, take as much time as you need. If you get something worked out, that'll be great. Just come back in and let us know that you're ready to proceed, and we'll put whatever it is that you've agreed to on the record. If not, then we'll hear your case in turn. All right, first case where opposition is signed in is 2018-252, 2280 Druid Park Drive, Adam Carballo. Okay, and who else? Okay, and sir, have you had an opportunity to speak with the applicant?
Initially, when they first moved in.
Okay.
No contact since then.
Okay, would you like the opportunity to speak with them now?
Sure.
Okay, all right. Just let us know when you're ready to go forward. 2018-259, 4018 Edmondson Avenue, Von Turner. Okay. All right, is everybody? Okay, and folks, have you had an opportunity to speak? No? Would you like to have an opportunity to speak with one another? Okay. Just go out the double doors to your rear. If you get something worked out, just let us know and we'll get you up here. 2018-261, 3364 Wilkins Avenue. This is Andre Jones. Okay, and who signed in that one? Okay, and have you folks had an opportunity to speak? No? Okay, would you like to speak with owner? No? Okay, have a seat. Okay, and that's the last one. All right. First case is 2018-226, 319 South Chester Street, Todd Newman. Come forward. Okay, you're Mr. Newman?
Yes, sir.
All right, and sir, we have this as an application to construct additions at the second floor and third floor with rear and rooftop decks. Is that correct?
That is.
Okay. Sir, if you would please raise your right hand to be sworn.
Yeah, you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Okay. Do we have staff reports?
Planning Department has no comment on this application. Thank you.
Thank you. All right, Mr. Newman, why don't you tell us about what you're proposing here?
Second floor rear addition and a third floor rear addition with a rooftop deck on the rear and on top of the third floor.
Okay. Looks like the existing dwelling takes up pretty much
The entire,
all of the lot?
yes, sir.
Okay. And so the second floor, will just go out to meet where the first floor is?
That's correct. And then the third floor, we're only going back 30 feet. We
Mhm.
spoke with the neighbors and we came to conclusion of only going back 30 feet that they were both happy with.
Okay.
And then on the third floor, there's a rear deck and then the rooftop deck on top of the third floor.
Gotcha. See that. Okay. All right, any questions?
Can I see the plans just to make sure, because there was a couple
Sure,
revisions?
sure.
Just want to make sure that you guys got the right ones.
All right. These are the ones I have.
These were the original plans. We resubmitted new plans.
Okay,
So
do we have?
So,
Thank you.
it was dated July 12th.
These are dated June 20th.
We have these which have July 12th and then revised August 7th. Are those the-
Yes, sir, these are the correct ones.
Okay, I see.
So on the third floor, we're only going
Trim
back
down the
30
third
feet?
floor.
Yes, sir. And the second floor, we're going full width.
Mm-hmm. All right. You said this was a revision made after you reached an agreement with the neighbor?
Yes, sir.
Anything further?
I'm sorry?
Anything further?
No.
All right. Thank you very much.
Thank you.
Let's do 2018-254, 4001 East Northern Parkway, Torrin Burris.
Good afternoon, Mr. Chairman, ladies and gentlemen on the board.
Afternoon, sir. You're Mr. Burris?
Yes, sir.
Okay, and sir, we have this as an application to use the premises for 4 dwelling units. Is that correct?
That's correct.
All right. Would you please raise your right hand to be sworn?
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
All right. Do we have any staff reports?
Yes, Planning Department reviewed this application, noted that this property is currently permitted for use as a multifamily dwelling containing 3 dwelling units, and that makes it a non-conforming use in the R3 zoning district where the property is located. The applicant is proposing 4 dwelling units, which would constitute an expansion of a non-conforming use, which the zoning code does not authorize. Therefore, the department recommends disapproval of the application because the zoning code prohibits expansion of non-conforming uses, which the existing multifamily dwelling is in the R3 zoning district where it is located. Thank you.
Thank you. All right. Sir, did you get all that from the planning department?
Just now.
No?
Yeah.
Okay, all right. They sort of put their finger on it, which is that in the zoning district which you're in, which is an R3, your property, I guess you currently have 3 dwelling units, and you're looking for 4. The 3 that you have are non-conforming. Now, because they're already legally established, you can continue those, but you can't expand it. So seeking a 4th unit would be expanding the non-conforming use, and the board doesn't have the authority under the zoning code to approve that.
Okay. Do I have any means of recourse regarding the project? Is not technically expanding the house per se. It's just building under or finishing off a basement to make it into another unit, and that still would not.
That wouldn't, yeah. So it's not just the, it's not, the physical size of the building. It's just the intensity of the use or the density.
Okay.
And here, R3 is a pretty low-density zoning district.
Okay.
So having 3 already is outside of the requirement. But as I said, it's already legally established, so you can continue that. But the board's without power to say that you can expand that to have a 4th unit.
Okay.
You asked about recourse. You could go to your council person
Okay.
to seek a zoning change to loosen up that requirement. But that's really the only place that I could direct you at this point.
Okay.
All right?
All right. Thank you, sir.
Thank you.
All right.
Next, 2018-256, 19 through 21 West Preston Street, Frank Brockman. Good afternoon, sir. You're Mr. Brockman?
Yes, I am.
All right, and Mr. Brockman, we have this application as a request to use the basement for a music and clothing store. Is that correct?
That is correct.
All right. Folks, if all those intending to give testimony in this matter would please raise their right hands to be sworn.
You swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right. Do we have staff reports?
Yes. Planning Department reviewed this application, noted that this property is within the Mount Vernon Historic District, and therefore any exterior changes to the building would require approval by the Commission for Historical and Architectural Preservation. The department recommends approval of the application. If granted, be subject to the condition that all exterior changes, including additions, demolitions, and alterations, are completed in accordance with an authorization to proceed issued by the Commission for Historical and Architectural Preservation. Thank you.
Okay. And that was the full extent of the planning department's comments on the appeal?
Well, there is another issue, and that is whether the building itself qualifies for consideration as a neighborhood commercial establishment. That would require basically the applicant to show that the building was originally constructed in part or in whole for non-residential use. To the best of the department staff's knowledge, this building was originally constructed as a single-family dwelling in the 19th century.
Okay. All right. Thank you very much. Okay. Mr. Brockman, I guess why don't we first start off with what it is you're proposing, and then we'll sort of
Okay.
move through everything else.
There's a commercial space in the thing that has been used as a commercial space for at least the last 6 years. It had been a vapory, and then it had been a like acupuncture place. Unfortunately, I missed the zoning when they changed it from I think it was B4, and then I assumed I'd get some in the mail, but I apparently went through a different thing. So I just wanted to continue it as a neighborhood business. already paid for the signage fees and other things, and I've been continuing to do that. I talked to my councilman and the neighborhood association. They're fine with it.
Okay. Yeah, I guess the issue, as you alluded to, was the change in the zoning code.
Right.
Where now, in order to have that commercial space, has to qualify as neighborhood commercial establishment, which generally is for structures which were originally built and used for non-residential purposes. As planning department said, the building, from their information, was originally constructed as a single-family dwelling. It's subsequently been cut up into apartments and has been used as such for some time, which would then remove it from the would remove the building, that is to say, from the ability to use it as a neighborhood commercial, because it had, although the commercial aspect of it had been a later acquired use, it's not one that that we could recognize now. And to use it, I think neighborhood commercial would only be permitted if your structure had 50 or more dwelling units. That is, kind of, if you've got, like a large apartment building, you've got the first floor commercial space, but I think you said that yours has somewhere around 10 or something.
Right, exactly.
So you're below that amount. And Mr. Baumgartner, this wouldn't fall under the new zoning change, would it, for neighborhood commercial?
It might. We'd have to do some research into the permit history. It looks like there is a use and occupancy permit issued in 2013. I can't quite tell if that's for the tobacco vape shop or for
that
the
was the vape shop, yeah.
Okay, that might qualify under the code change.
Mm-hmm.
The only hurdle then the board would have to face is at the time of the application. We applied the law at the time of the application.
Yeah.
So the time of the application, that change wasn't in effect.
The law changed very recently, within the last week. It was signed into law by the mayor then within the last week.
So what I was, If you dismissed your appeal and refiled it, then you would be able to take advantage of the subsequent change in the law.
So because we applied beforehand, then the law changed?
Well, but
At
so.
the time of application.
Yeah.
So if the rule typically is that if you come before the board
Right,
and there's a decision in your case, then you can't reapply for a year.
right, I can,
If prior to a determination by the board, you dismissed your appeal, that bar wouldn't apply. You could then reapply,
which would take about 3 weeks,
and then you'd be able to,
and then it'd be another 3 weeks.
maybe.
Okay, I guess that's our only course of action.
Okay.
that-
We'll mark it down as postponed for right now, and then you can take care of everything else.
So with the new law, then it's okay. So I should probably come with, because I talked just today with the vice president of the neighborhood association,
Mhm.
and he wanted to send us a letter, except he couldn't find the form letter that they're supposed to do, because the person was in California who had contact of that. So I suppose you want any of that would be more helpful.
Sure, that would be certainly helpful to know that the community association is supportive.
Okay.
All right.
Okay.
Okay.
Thank you.
Thank you.
All right, 2018-256 is postponed. But, yeah, postponed for now, and then you can subsequently withdraw it. 2018-257, 1125 South Charles Street, Sharon Johnson. Afternoon.
Good afternoon.
All right, Ms. Johnson, we have this as an application to add live entertainment to existing restaurant with outdoor table service. Is that correct?
Correct.
All right. Ma'am, if you would please raise your right hand to be sworn.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
We do.
All right. And do we have staff reports?
Planning Department has reviewed this application and is recommending approval of the application. Thank you.
Thank you. All right. Ms. Johnson, why don't you tell us a little bit about what you're proposing here?
It's just a small venue for acoustic, mainly guitar, and it's the older clientele in a neighborhood that's full of young people. And just to add some entertainment for, I guess, the older neighbors. And it's very walkable neighborhood. It's in Federal Hill. So it really doesn't impede traffic because most people walk to the location. And I have a letter or an agreement from the Neighborhood Association, from South Baltimore Neighborhood Association.
Okay. Do we have that in the file already?
No, I
We
have
do
a
not.
copy.
We don't have that in the file yet, if you have a copy.
You can pass that up.
Thank you very much.
I'm looking at the drawing here. I'm trying to see where the live entertainment would be located.
In this area right here.
Okay.
In this side, there's a little walkway here, and there's like the bar.
Okay.
I mean, things might be moved. Tables might be moved around.
Okay. All right. Now, you've also got a request for live entertainment here. Not live entertainment, but outdoor dining.
That was from before. That was from, I think, 2013.
Oh, okay. So you're not looking for that?
That's been already approved, I think, in, where was it? Where did I see that? It was already approved. I mean, I already have that from when I took over the place. Oh, here it is. Oh, nope, that's not it. Oh, yeah, right here.
It's in a C1 district, so it's permitted by right.
Right, yeah. Okay. Yeah, I don't need it. Okay. All right, any questions?
Nope. No.
All right, thank you very much.
All right, thank you.
Calling 2018-252, 2280 Druid Park Drive. Did they leave?
Are they ready? They just popped out.
They just told me they wanted to postpone.
Yeah, that's what I understand. Do you know, can you step out and see if they're still here?
Probably going.
All right. This is case number 2018-252, 2280 Druid Park Drive. Counsel, can I?
Herbert Burgunder on behalf of the applicant.
All right, and I understand there's a postponement request which is being made?
Yes, please.
Okay. Opposition in line with that? You can step forward, sir.
Presuming I can attend the next hearing, sure.
Okay. All right, and your name for the record, sir?
Ryan Bodie, and I'm the resident at 2282.
All right.
And I've given Mr. Bodie my business card, so he'll send me his contact information so we can make sure that he gets, if it doesn't get through, you were going to
I
tell
will.
the city the email address, but I'll make sure that he gets notice.
Okay, all right. Thank you, gentlemen. 2018-252, 2280 Druid Park Drive is postponed.
Thank you.
Thank you very much.
Are there copies of the planning committee's report prior to me leaving?
Not that I have, unless, Mr. French, do you have an extra?
This is
252?
I'll need to have.
All right. 2018-262, 2116 through 2124 Acewith Street, Nigel McIntosh.
Afternoon.
Afternoon, sir. All right, you're Mr. McIntosh?
Yes, sir.
All right, Mr. McIntosh, we have this as an application to use the premises as a music recording studio, is that correct?
Yes, sir.
All right. Gentlemen, if you would please raise your right hands and be sworn.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Yes, sir.
All right. Do we have staff reports?
Planning Department has reviewed this application and has no objection to it. Thank you.
Thank you. All right, Mr. McIntosh, why don't you tell us about what you're proposing here?
Proposing to build a recording studio, audio video room, and podcast room for the location.
Okay. All right, here's the drawing. All right. Any idea of your hours of operation, days you'd be open, et cetera?
6 days a week. Hours of operation 10 a.m. to about 2 a.m.
Okay. And standard soundproofing,
Yes,
et
sir.
cetera?
This is my architect right here. He's doing all the.
Okay. Sir, if you could identify your name for the record, please?
Joshua Nicodemus.
Okay, and Mr. Nicodemus, can you discuss sort of what goes into the soundproofing and the protocols that get incorporated into uses such as these?
Yeah, we're actually working with a separate design engineer for the sound aspect. And we haven't seen his full drawings, but there's very heavily weighted sound panels on the ceiling, several layers of drywall walls with spaces in between to kind of block the sound. They've spent a lot of money on getting this done the right way, so I really don't think there's going to be any sound transmission outside of the building, even through in between the studios. It's very important. There's 3 different studio areas within the building, and they can't have one,
Well, you need
two at the
to.
same time. They can't have any sound mixing. So
Okay.
they're going above and beyond, in my opinion, a little bit to make sure they get it right. So it's a pretty impressive design.
Okay. Okay, any questions?
No?
All right, thank you both very much.
Thank you.
Thanks, sir.
All right, 2018-263, 6702 Park Heights Avenue, Atron Resnick.
Hello, it's Aaron Resnick.
Ah, okay. Sorry about that.
No problem.
All right, Mr. Resnick, we have this as an application to construct a 2-story rear addition and to use as a library and offices. Is that correct?
Yes.
All right. Sir, if you would please raise your right hand and be sworn.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
All right, and do we have staff reports?
Yes, first, we have a letter from the Fall Staff Improvement Association. They're writing that they support the above request made on behalf to construct a 2-story rear addition and use as a library. The board has spoken with the appellant and received written documentation of the plans for the property. That is the end of my report. Planning.
The Planning Department has reviewed this application and is recommending approval. Thank you.
Thank you. All right, Mr. Resnick, why don't you tell us about what is being proposed here?
Yes, sir. I don't have much to add on the planning department's report, just that we're doing a rear addition 2-story to be used as a library. And I have a copy of the letter of support here as well.
Okay, and what kind of
You guys have it on file?
library are you going to be operating?
It is a religious institution or a cultural facility.
Okay, so somewhere where I guess people come, be able to utilize the text, et cetera,
Yep.
do research. Okay, and we've got that there's a request for offices, which is associated with the request, is it
Oh,
correct?
yes. Sorry for leaving that out.
All right, and how would those relate with the library use?
That would just be for the administrators.
Okay.
I think it's about 3 or 4 offices above.
So the offices really wouldn't, so it's not that the offices are secondary, it's just, are like a primary use, is just for the staff that's working there?
Yes.
Okay. All right, any questions? All right, anything further?
No.
Okay, thank you very much.
Thank you.
We'll call these three together. 2018-264, 3447 Chestnut Avenue. Calling it together with 2018-267, which is 3449 Chestnut Avenue. And 2018-268, 3441 Chestnut Avenue. All these cases are Ian Carmichael.
How are you doing today?
I'm sorry, sir?
How are you doing today, sir?
Good.
You right up there.
Folks, are you together with this appeal? Okay. You guys are in opposition, or were you? Okay. Have you had an opportunity to previously speak with the applicant?
Yeah.
Okay.
I would like to say that no, we haven't, because we scheduled a meeting and he hung up the phone on me, and I tried multiple times to reach out to him to have a meeting with him, and he did not answer me. So it's not entirely true, sir.
Okay. Would you folks like to have a discussion to see if you can resolve whatever differences you have?
Community Council zoning and land use committee head who stated that he offered an opportunity for him to have a meeting with the community council.
Okay. Leaving aside whatever may have happened in the past or didn't happen in the past, the pending question is, would the parties like to have a discussion now to see if they can resolve whatever differences they have?
I don't think I can be swayed to be in favor.
Okay.
I'm open to having a discussion, but if he's not, I'm willing to proceed as well.
Okay, all right. We're not on the record. We're not on the record.
We are on the record.
We're not.
We
All right.
are.
Folks, would you like to have a discussion?
I'll go and talk to him.
Okay, why don't you step back and you can have a
Thank you very
discussion with
much.
one another and see if you get something resolved. 2018-265, 2200 Eastern Avenue, Rand Shapira. Calling again, 2018-265, 2200 Eastern Avenue, Rand Shapira. 2018-266, 4214 Mortimer Avenue, Jamal Harrison Bryant.
Good afternoon. I'm Emerson Dorsey, attorney for the Empowerment Temple.
Okay.
And I wouldn't make a proffer, but
Okay, all right. And Mr. Dorsey, we have this as an application to use portions known as A, B, and C for offices. Is that correct?
That is correct. A little bit of background about the property.
Before we get too far down the track,
okay.
let's get anyone sworn in that's going to be testifying, okay? All right, if all those intending to give testimony in this matter would please raise their right hands to be sworn.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, and do we have staff reports?
Planning Department has reviewed this application, noted that this property is predominantly used as a parking lot. However, it does also have 3 buildings, separate buildings on it. Their combined area is approximately 23,500 square feet. This site is within an urban renewal area, and in this particular district, the offices, the zoning district, I-1, the offices as a principal use are not listed as permitted or conditional use, and therefore would not be allowed. The applicant would need to provide the board information concerning the use and occupancy permit status of this property as of June 5th of 2017 in order to allow consideration of the property's use as a non-conforming use, office use. Otherwise, the department has no objection to the application if the applicant can provide information showing that office use of this property was lawfully established as of June the 5th of 2017. Thank you.
Thank you. All right, Mr. Dorsey.
Yes.
You were about to give us some background, so why don't you do that, and you can go through what's being contemplated for the property, and we can also discuss the property history and all that.
Good afternoon. The Empowerment Temple acquired this property at 4214 Mortimer Avenue in 2015 from Baltimore Gas and Electric Company. Baltimore Gas and Electric Company had owned portions of the property going back to 1908. It had served for up until really 2014 or so as a training facility and offices for Baltimore Gas and Electric Company. Through the various consolidations with Exelon and Constellation over the years, the facility was no longer needed by Baltimore Gas and Electric Company. However, Baltimore Gas, BG&E did subdivide the property and reserved a portion that now has a Nome Avenue address as a future substation site. This property is adjacent to Empowerment Temple's worship facility, which is at 4217 Primrose Avenue. This property kind of is like south of the particular of this particular parcel, and there were the existing buildings on it were used by BG&E up until the sale to Empowerment Temple. Empowerment Temple's immediate use for the property was to pave it and use it for parking. And if you look at the zoning history for 4217 Primrose, you'll see some of the issues that were related to that. So that was their immediate urgent plans, and that was exactly what they did immediately. Now, as they have grown into the facility and have the use and with financing and other programmatic plans, have now desired to use those buildings that existed for offices. They're going to do some things with some training, some counseling, some other services in the neighborhood, and want to use those offices there. Of course, with the zoning change, offices in the I-1 zone are only conditional if, in fact, it was an existing non-conforming use that, while Empowerment Temple had not actually used them, is that they were existing non-conforming use at the time they bought the properties. So the nature of the request is now to permit the office use that otherwise isn't permitted in I-1 except as an accessory use, and is not the primary use for another use that's going to be used of that property. So.
Okay. So if I got it right, BGE owned portions of the property going back to the early 1900s.
Actually, they owned the entire property. Some portions of it they acquired in 1908, but they acquired other parcels, and at the time, in 2015, they owned the entire parcel.
Correct. To continue, BGE was the owner of at least portions going back to 1908. In 2015, the church purchases the entire parcel, including the structures that are on it, from BGE. Up to the time of the property transfer, BGE had used the structures on the property for an office use. The church, once they purchased it, used the property exclusively for parking, paved the property, used it for a parking lot. No use was made of the structures. The church now is sort of maturing in its development plan and wants to utilize the structures now for offices related to various services that the church conducts. Okay.
I want to point out that one of the buildings, they do plan on doing it for job and employment training. That is a permitted use under the I-1 zoning.
Okay.
But there will be some offices in there related to that, so just include it all in one conditional use.
All right. And when we get into sort of what the services are, you talked about the job training. That's one
They will
aspect
be
of
doing
what
some
these-
counseling. They will be doing some mental health and other similar types of counseling in there. They're going to be using it for some of the facilities for offices for the church facility itself. But they are talking to prospective tenants to also provide some counseling and other services into the particular in two of the buildings specifically. Didn't want to get too far into discussions and lease negotiations with other tenants and so forth until obviously the use, the conditional use was in fact established. So that's part of the whole process that's coming here now.
All right. Okay. Any questions? Okay. Thank you very much.
Thank you very much.
Thank you. Uh, 2018-275, 3101 East Baltimore Street, Herbert Burgunder. Afternoon.
Good afternoon. Herbert Burgunder on behalf of the applicant for 3101 East Baltimore Street.
All right. Mr. Burgunder, we have this an application to use the basement and the first floor as a restaurant with accessory outdoor table service. Is that correct?
Correct, and retain the apartment above on the second floor.
Okay. All right. If all those intending to give testimony in this matter would please raise their right hands to be sworn.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
All right. Do you have staff reports?
Yes, we have 3 letters of support from residents at the 100 block of North Elwood and someone in 3039 East Baltimore Street in support, and a letter from the Patterson Park Neighborhood Association. They write that I'm writing to provide that our organizational support of the Patterson Park Neighborhood Association for appeal noted above for 3103 East Baltimore Street. The Patterson Park Community Association has shared their vision with this new business. They have seen and reviewed the plans for the renovation of the property and believe it will be beneficial for the community.
Planning Department reviewed this application, noted that this particular building is somewhat unusual in that it was actually built for non-residential use and used for simultaneously 3 different non-residential purposes originally. The department also notes, however, that the neighborhood commercial establishment category requires all activities to be within the building and not outside. And on that basis, the Department of Planning recommends approval of the application, subject to the condition that no exterior seating or dining facilities are provided, and in addition, subject to approval of all signage by the Department of Planning. Thank you.
Thank you. Okay, Mr. Burgunder, is your client amenable to the conditions offered by the Planning Department?
The condition with regard to the approval of the signage, yes. With regard to the outdoor seating, no. But we'd like to, I don't interpret the law the same way, so I'd like to have an opportunity to present that to the board.
Sure.
I was before this board on 1500 West Pratt Street with the very same request, and we asked for outdoor seating. And in that case, the Planning Department supported our request under the, I think it's the more reasonable interpretation of the code provisions. So I'd like to just sort of introduce my client and tell a little bit about him, because I think it's a neat story to tell, and it's here for universally accepted and good purposes. So Max Rhyme here is, he runs a restaurant, or not a restaurant yet, runs a business called Pie Time. So he makes pies. So most people are in favor of pie, and he also intends to sell coffee. So when not everybody drinks coffee, most people drink coffee. And so he's here, we're here for pie and coffee in support of that, in sort of that quest. But Max is also at the Baltimore's Farmers Market, and he is soon hoping to be a graduate of one of Baltimore's first kitchen cooking restaurant incubators. So Be More Kitchen. I don't know if you've certainly had them before this board, and certainly have heard of them. So he's been working hard and honing his skills, and is now ready to open his first business here in Baltimore, and found a great location for it. A little off the beaten path, but as the Patterson Park Neighborhood Association letter of support and the letters from the other neighbors indicate, he has presented to them a plan that they are in whole support of. So I don't know, Max, if you wanted to say anything as far as introduction and what you plan to do there?
Yeah, well, of course, I'm Max Rhyme.
Step forward and use the microphone.
Thank you.
Spell your last name.
R-E-I-M. And I've been in business for about 3-4 years now, so this will be our first brick and mortar location. I live 5 blocks away on the corner of Linwood and Fayette, so very much tapped into the neighborhood. I'll be able to walk to work and maintain the property, and it's really nice. We're going to have something commercial north of the park, which I think is really exciting, and we've demonstrated that with the letters of support from the neighbors and the neighborhood association. And when it does come to, I guess, the outdoor seating and the interpretation, it's 3 small 2-top tables, and if you look at the drawing, the handicap ADA ramp and so on, so it won't block anything at all in terms of the sidewalk, because the handicap ramp will already be there. And, well, who wouldn't want a cappuccino and a slice of pie outside on a nice day, I guess.
And so tell a little bit about the pies and your experience very quickly about the Be More Kitchen.
Yeah, so Be More Kitchen, first incubator space in the city. I would be one of a few members that have kind of graduated into brick and mortar, demonstrating the success of that concept and the success of that concept within this city. And also just like, we've been a farmer's market business, so we buy all local fruit. We do fresh fruit pies. The savories are kind of more gourmet options, and this restaurant will give us a big opportunity to expand sides and offerings. Also, I think it's important to note that it will be a daytime business. So a lot of folks will be off at work and so on. So in terms of impeding traffic with outdoor seating or anything like that, I don't think we're going to run into issues there, because we'll be open 6 to 3.
And you're going to serve coffee as well?
Yes, so full service espresso will be a big focus of the business concept. We're going to get a hand hammered Italian espresso machine. It's also a lever machine like we use at the farmers market. So there's 3 on the eastern seaboard. So it'll be exciting to put that right in the neighborhood. Yeah, I'm excited.
So with regard to the use of the neighborhood commercial establishment, the property presently is it's a grocery store, a small grocery store. It had not been renovated, repaired, or updated, so obviously the plan is to do that. It's a corner property. It's obviously an old-fashioned corner store. As Mr. French said, it's been used for many years as effectively a neighborhood commercial establishment. So we believe we meet the requirements for the neighborhood commercial establishment. It's not really a conditional use conversion to the extent that it's a change in the use, but we believe we meet the requirements for the conditional use conversion as well under 5406. So there's nothing that's going to cause any harm or danger to the public safety or health. With regard to the outdoor seating, and the reason, Mr. French is correct that there is a statement in the new zoning code that says that the business uses, servicing, processing, and storage uses must be located within the building. Outside storage or display is prohibited. We're not planning to do any of those things. So outdoor would be eating. So people would buy their pie and coffee and then go sit outside. So that's the outdoor dining. Certainly we don't, I wouldn't consider it in sort of regular reading of English definitions that eating would in any way be conducting business, or otherwise I've been conducting a lot of business. So anybody can go and in their neighborhood. I don't think it's adverse to the intent of the neighborhood commercial establishment under 14328G to have the outdoor dining requirements under 14329. So obviously the requirements for outdoor dining has to be an accessory use to the principal use, which is what we would have here. It has to not impede, interfere with pedestrian access or parking. Obviously, we would design it as such and have suggested so on the plans. And all dining areas must maintain 5-foot sidewalk clearance at all times. Obviously, you have to get a minor privilege permit. So the question is
No service of food or drinks.
well, you say no service of food, so
No employee or representative of the restaurant is bringing out food or drink to these tables.
No
Correct.
table service, no, sir.
Okay.
So it would be limited to people eating there, and I don't think that would be violative of the condition under the neighborhood commercial establishment. Certainly no outdoor storage or display. It would be some tables for people to enjoy a fine cup of cappuccino and a slice of pie if they would seek to do so. And it's similar to the 1500 West Pratt Street, same idea. That we would have just a few cute two-tops for people to enjoy their coffee. Nothing would prevent, I think the idea behind the requirement that all the stuff of the business be inside is that they didn't want storage. The legislators didn't want storage outside. They didn't want people manufacturing something, banging, making noise. Obviously, anybody can sit out on their front stoop and have a cup of coffee. So this would be akin to that. So we think it's compatible with the neighborhood, and we think the reading of it to the extent that you couldn't have an accessory use.
It's not quite the same as someone having a cup of coffee on their stoop, because I think that the point of the code was that the neighborhood commercial establishment was an accommodation between commercial uses existing in residential areas, the concern being about people gathering for, so you get concentrations of people gathering in a residential area, and then just sort of the noise, traffic, whatever, that spills off from that. When I go outside and I have a cup of coffee on my stoop, I sit outside. It's a very quiet place. It's me and my coffee and maybe a dog.
Okay, well, as long as the dog doesn't bark.
That's true.
But I do think that that Mr. Rhyme has gone to his neighbors and sought support for that idea, and I do think that
that's the case in a lot of neighborhood commercial cases.
Sure, and
maybe, but it's not really sort of a neighborhood plebiscite whether.
No, I understand that, but
do you want to have this? Do you not? It's a question of what's permitted in the code.
Sure, and we think that a fair reading of the code is you couldn't have, if there was to be a prohibition.
Well, who owns the tables and the chairs?
The business would own the tables and
business
chairs.
is putting the chairs and the tables that it owns outside on the street.
That is true.
Okay.
But nothing would prevent anybody from doing
the same as if you were, say, storing things out on the street.
I would beg to differ. I understand your point, but I don't think that conducting business or servicing, processing, or storage uses, I don't think sitting at a two-top table having coffee would be considered any of those things. And it wouldn't make sense because restaurants are a permitted use, and maybe it's a hiccup in the code and they need to revise it, but I don't think that in this instance that having people enjoying their coffee outside, even on tables owned by the restaurant, would be violative of the code. If the code says in the very next section, accessory uses are permitted in the neighborhood commercial establishment. So you can't have the right to do it.
Accessory to.
Yeah, accessory
It says accessory uses are permitted.
That is true.
To a principal use, yes.
Correct, and this is an accessory use to outdoor dining requirements under 329 are accessory to the permitted use.
That doesn't necessarily mean in zoning districts where outdoor table service is otherwise prohibited.
Well, it doesn't say that outdoor table service is prohibited. That would be an interpretation.
But the idea is that what that's simply saying is that there's something you can do called outdoor dining, and you can do that as an accessory use to your principal use, but your accessory use still has to be, the question is whether that accessory use is permissible wherever you're seeking to locate it. Obviously, if it's not permitted there, then you can't do it there.
Of course.
Here, the neighborhood commercial operates as an exception.
Sure.
That is where otherwise, where an otherwise unpermitted commercial use in a residential area would not be possible, would not be permitted. You're able to have it where where you can establish the neighborhood commercial use, which is that the building was, as originally intended and constructed, et cetera, was intended for a commercial purpose. Now, do you think that in 18 whatever, when they built the structure, that this property had outdoor dining associated with it?
Potentially. I don't know either of us are qualified to testify to that.
That's correct, but only you have the burden with respect to that.
I understand that, but I do think that I would encourage the board to not read the provisions so narrowly, because I understand your perspective about having noise and other things, but there's sort of a Jane Jacobs perspective of it to, eyes on the street, the life and breath of cities, and obviously the neighborhood association, and while I appreciate the fact that it's not a plebiscite, but they do very specifically support the use of the outdoor dining. They say so specifically in their letter of support, and so do the other neighbors. And I think that what Mr. Rhyme has testified to, which is the excitement that the fact that there's going to be a restaurant north of Patterson Park in a neighborhood that frankly needs this amenity and it improves the lives of everybody. I don't see that having potentially 6 people sitting outside would be any harm to the neighborhood, and certainly the neighborhood association agrees to that effect. And I don't think that a very narrow reading, or maybe it's a super expansive reading of business servicing. If there's no table service, there's not somebody out, taking your credit card or doing anything else than that. It's a passive.
Because I took a look at the definition of outdoor dining, 1310R.
Yes.
And it really doesn't talk about table service. It talks about.
Yeah, it's just dining.
It talks about outdoor dining means an outdoor seating area that adjoins a restaurant or carry-out food shop and is used by patrons to consume food or drink. So that would encompass somebody picking up a cup of coffee and a piece of pie and taking it outside without service.
That is correct.
Yeah.
That's what we're asking for, is the outdoor, it's straight up outdoor dining.
Okay.
Yeah, so nobody would be, it's not a waiter, waitress, a server assisting you. It's a passive experience, and we don't believe that it meets the, certainly in the class of servicing, processing, or storage uses, and it's definitely not outside storage or display.
Well, we certainly do understand that.
We're quibbling, but I understand your point.
Well, I was going to say that in the position the board is in, is that code is a new code, one that was enacted by the city council. And the neighborhood commercial establishment, while in some areas is a very welcome addition, in others, there's a very hostile addition.
Sure, but that's why it's a
and-
conditional use.
And the board has to apply the code citywide, and that the possible outlet for the kind of policy discussion that you're seeking to have may be more appropriate in the council chamber as opposed to the board's chamber.
I understand.
And I think that if we had that discussion, we might find that there's a great deal more, I think that there's a greater spectrum of views as to the reception towards neighborhood commercial establishments.
Sure, but that being said, that's why it made sense from a planning perspective and a zoning perspective to have this as a conditional use. So the board, when they make a decision on this applicant, can judge this applicant at this location. That's what the conditional use, the legal standards
The
are.
conditional use aspect is just simply the neighborhood commercial aspect.
Well, I understand that, but it's an accessory to the conditional use application. So I do
Within
believe
the
that.
definition of the conditional use that we're talking about, it requires that that all activity related to that use be conducted indoors.
Well, again, we don't believe there's any activity related to that use that's being done outdoors other than
Irrespective of the fact that the
that
business.
people walk outside and drink their
irrespective of
coffee.
The fact that the business is placing its tables and chairs outside, offering those to their patrons as an aspect of their business. Certainly, there is a quality to that which the business regards as potentially more inviting for patrons as opposed to somewhere that operates as a pure carryout. So if one business is located here that has tables, chairs outside, and there's another business that's across the street that doesn't have that, clearly the business that offers that to the patrons sees that as an accommodation, which may make it more attractive to
Yes, that's
patrons.
what we want.
That's right.
That's what we're trying to do.
That's exactly right,
We're
which gets back into that part about the business.
I think this should be judged on the merits of itself, and the board, I think, has the authority to approve it under the code, and I think that the board is imbued with the authority to interpret what the legislators have written, and I think reasonably having an accessory outdoor dining limited to just dining and consuming food as opposed to service or any other aspect of it. I do think it was intended by the legislators, and I can't imagine they would not want there to be outdoor seating if in the neighborhood in which it's proposed, at the location at which it's proposed, wouldn't cause any of the harm that's listed in the statute. And obviously, I don't think we're making policy for any other restaurant or bar or any other activity, coffee joint, pie place, if there are any other pie places. I think there's
But
one in
when you
Hampton.
started, you began with the case that you had that was located in the west.
Sure, the pizza shop, and the pizza shop may be a little less attractive corner to sit on 1500 West Pratt. Maybe that's a little aspirational, but I don't think this is aspirational.
Oh, I think that the idea was the same as what you were talking about before, the idea that, by sort of activating the streets with commercial activity,
Sure,
with,
more eyes on the
people
streets.
outside,
That's
you
safe.
make use of that space, and the public reclaims it from
from
other less
potentially bad guys.
savory.
But from 6 to 3 is what we're talking about. So I do think that's a factor that the board should consider. Anyway, I think it's worthwhile.
6 o'clock in the morning.
Yes, you wake up early and get, that means that
On the dog walk.
Max has got to wait, he's got to wake up earlier than that to make the pie. So we would ask the board's support, obviously for the change to the coffee shop. We would ask the support for the minimal request to have the outdoor dining. We do believe it fits in the requirements of the code. Thank you.
All right. Thank you. Thank you. Good luck to you. 2018-265, 2200 Eastern Avenue, Rand Shapira, and/or Nate Prettle.
Good afternoon.
Afternoon. Again.
Yes. Apologize for being absent.
That's okay. And this might have been something that you were sort of called to pinch hit on at the last minute.
Yes and no, and also I didn't realize the board would be moving so quickly today. It's nice to see.
Indeed.
Once in a while.
Yeah.
All right, Mr. Prettle, we have this an application to use the premises as 4 dwelling units. Is that correct?
That is correct.
All right. You've already been sworn, so we can move on to staff reports.
Thank you. Planning Department reviewed this application, noted that there is a very minor variance of lot area required. Although the report says 1%, it's actually more like 1/10 of 1% required. And in addition, there would be a variance required for off-street parking of 1 space. However, this particular neighborhood is one in which there essentially is no off-street parking available pretty much to anybody. The department is therefore recommending approval of the application. Thank you.
All right. Okay, Mr. Prettle, why don't you tell us what's being proposed here?
Sure. So the proposal, as stated, is to reuse the existing structure, which takes up the entirety of the lot, as 4 dwelling units. This particular structure has had a number of uses over the years. I think it was a lawyer's office. It had a couple dwelling units in it. Some of these uses are documented, some of them are not. It's right across Collington Avenue from the fire station. I forget the engine company number, but a very active fire station, and also about a half a block from the Patterson Lanes bowling alley, as well as several establishments, as Johnny Rad's Pizza Bar, one of my favorites, as I used to live about a block away from here. And so we're here seeking 2 very minor variances. I would actually disagree that we're seeking a variance to off-street parking. This is in a C1 zoning district, which all uses are exempt from off-street parking requirements. As a practical matter, there is no ability to provide on-street parking, and should the board disagree with my interpretation, this would also be something that would qualify for a historic structure parking exemption. But again, C1, to me, it's clear that there's no off-street parking requirement per Section 16 of the zoning code. In regards to the variance for lot area.
Say that on-street parking is impossible. Do you mean
I said off-street? I'm sorry, off-street parking is possible at this location. On-street parking is, I believe, mostly metered along Eastern Avenue to a certain time, and there's quite a bit of turnover as well, and it's also by several bus lanes at the corner of Eastern Avenue and Patterson Parks. There's public transit readily available, I should say. And in regards to the variance standards, this lot is unique in the area. It's the only 16-foot wide lot on the entire block. The rest of the lots are between 12.5 feet to 14 feet wide. It's a corner lot with frontage on 2 different rights-of-way. And again, the degree of variance we're seeking, I would think it's safe to say this is probably the lowest degree variance that I've ever been in front of this board seeking. It's 1/10 of 1% of the lot area, or in 10 square feet, where out of what would be required for the 4 units is 1,500 square feet. There's a chance that if there was a survey done, maybe they would pick up this at 10 extra square feet. Maybe they would lose 10 square feet. It could go either way. But I think, suffice to say, it's the minimal variance required for the property. I discussed this with the community association president, and because of such a small degree, they were not interested in being a part of it. They did not oppose it. That's his words, not for the association, but they decided not to take a position. And I think it will be a great addition to this stretch of Eastern Avenue. It will add life to the street. This is sort of what the C1 zoning district, I think, intended for when it was approved by the council, is to allow the reuse of these buildings, particularly this structure, which is the largest on that block as well. Not only is it the largest lot, but the structure is the largest and taking up the entirety of the lot. And I think 4 units would not be considered overcrowding by any means, and I would urge the board to support the application. I'd be happy to answer any questions.
Any questions? All right, thank you.
Thank you, and if I may add, Mr. Chairman, I'd like to just thank you for your years of service to the board. I mean that sincerely, and it's been a pleasure to be in front of this board with you, chairing it with so many great projects, and I think made lasting impact on the city. And again, I thank you for that.
Thank you very much, Mr. Brittle. It's been good seeing you grow in your career over the years. I remember when you first started appearing with Mr. Berry and seeing you go through your career to this point. It's been a privilege.
Appreciate that.
Take care.
Thanks. I'm sure I'll see you around.
I'm sure. Take care.
Thank you.
All right. Okay. Let's call. All right. 2018-264, 3447 Chestnut Avenue. 2018 through 267, 3449 Chestnut Avenue. And 2018, 268, 3441 Chestnut Avenue, all Ian Carmichael as applicants.
I just told the gentleman over there for 3441, I'm withdrawing that.
3441. Okay, so that's appeal number 268?
Yes.
All right, so that is withdrawn. And then you are proceeding with 2018-264 and 2018-267, is that correct?
Yes, 34, 47, and 49.
Okay.
Yes.
And folks, can you identify yourselves for the record?
I'm Rena Abrams. I live at
Can you
3445.
use the microphone?
Sorry, Rena Abrams. I live at 3445 Chestnut Avenue.
Okay, sir?
And my name is Lawrence Wixulis. I live at 3451 Chestnut Avenue.
Lawrence.
Larry Lawrence. Yeah. Wixulis.
Last name.
Spell your last name.
Wiczulis.
Okay, and Mr. Mr. Carmichael, I think that we have these, that is appeal number 264 and 267. We have them similarly described. They're both appeals to construct a rear, to demo rear addition and construct a two-story rear addition at both of these locations. Is that correct?
That is correct, sir.
All right. Folks, to follow those intending to give testimony in these cases will please raise their right hands to be sworn.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
All
I also
right.
have another gentleman here who's the owner on the block in support.
Okay.
He raised his hand.
Oh, he did? Okay, all right. Do my staff reports.
First, we have the letter from the Hamden Community Council indicating they are willing to work with the applicant, but I gather he hasn't contacted them, or they claim he hasn't contacted them. I'm not sure. Specifically, and there is a letter from a resident at 3453 Chestnut Avenue who cannot make it to the meeting, and that applicant is willing to support Mr. Say it again, Witzulis's objections, and they repeat what he is probably going to talk about: blocking light and air, the character of the community. That's the end of my reports.
The planning department has no comment on these applications. Thank you.
Thank you. All right, Mr. Carmichael, why don't you talk to us about what is being planned for both of these locations?
So 47 is a single dwelling unit, and there is no usable basement on it. When speaking with my engineer, in order to be able to get the highest and best use for the property, we went through to get to about 75 feet in order to fit 3 bedrooms upstairs and 2 full bathrooms. Right now at an R6 zoning district, with the demolition of the garages, I'm able to go at 60% lot coverage, which would be 67.5 feet. We decided to go for the zoning variance because we felt that that extra 7.5 feet will give the best layout for the property and maximize the market value for such a long lot in that area. I counted, I think, 8 other properties on the 34 and 3500 block that went out just as far, if not even further, than what I'm proposing to do when I was driving through. I also went through and knocked on a lot of community members' doors, and I have about 20 different property owners that signed off after reviewing the plans that they were in support on the 33 through 3500 block of Chestnut.
Okay. like the proposed addition that you're going to construct here is looks like it's goes back maybe like 25 feet.
I think it would be more, are you talking about 47 or 49? Sorry.
Sure. It's 47.
47, I think it's more about 30 feet, honestly.
Looks like, it's hard to see, looks like maybe 32, maybe?
Yeah,
29 additional.
yeah. And the property at 3449 is already at 75 feet on the first floor, but it's not structurally sound. We have to tear it down and rebuild it. And for the layout at 3449, because it's a legally zoned 3-unit, it gives us, right now they've got like 2 studio apartments that just, you have to enter actually through the back alley in order to get into the property. And there was no way to build it a legal 3-story on 3449 with entrance through the front without making an extension on the first and second floor.
Both properties are currently improved with a existing 2-story garage.
Yes, and in the plans is to demolish those garages.
Okay.
Those are, because they're not structurally sound, but whatsoever.
Okay. And are you going to rebuild them or just going to have
No, keep them as a parking pad.
Okay, all right. So for all intents and purposes, you're taking that structure, putting it on the back of the house and adding about 10 feet.
Correct. It's actually, I did the math on it, it was 7.5 feet. Through what the current, so the current R6 zoning with the demolition of the garage allows me to go to 67.5 feet. I'm asking for 75.
Plan will be to have that, you were talking before about, I guess, the existing studio apartments or something?
So the plan on 3449 is, because it is a legally zoned 3-unit with a multifamily dwelling license, but it's got a very obsolete layout, meaning that the second floor apartment, they have to enter through a trash alley, and well, it's actually Bunneke Street, it's a legal street, and that's why the city allows it, and walk up almost fire escape kind of on 3447 and then cross back over to 49. We're going to eliminate that and create the entrance all in the front for everybody so that you can go upstairs and there'll be 2 apartments, and then in the basement there'll be, or in the first floor there'll be 1 apartment. So it'll stay 3 units, we're just reorienting it to a more effective modern layout.
Mr. Carmichael, your application says the proposed use for 49 is as a single-family dwelling.
That is incorrect. It's going to stay a 3-unit.
This is your application.
I understand that, but
So I'm reading off your application.
I mean, my engineer sent it in, so I mean, and the plans are for a 3-unit. I must slightly just a clerical error.
That's a pretty good-sized clerical error.
Trust me, I'm like that. I'm not aware of that because I would literally go and talk to my engineer, who was here earlier, Mr. Nicodemus, who's been in front of this council many times. So he's very well respected, at least I know in the community, and doesn't make mistakes very often. So I'll obviously speak with him about it.
So Mr. Baumgartner, we do not have, is this correct? We don't have the floor plan for the 3-unit building? At least I don't.
I have the floor plan right here. May I?
Yes, please.
The plans we have in the file don't reflect the number of units.
Okay.
Thank you. Since density wasn't an issue, it wasn't required on the initial intake.
that's with respect to 49.
Yes, sir.
Okay, and then 3447 Chestnut Avenue, which is appeal number 2018-264. That one is a single-family residence?
It is a single dwelling, yes.
The sign that you posted, I can't remember if it's required to have the number of dwellings or not, but what was on the sign?
I'd have to bring up the picture, but I know that, so Gina Campbell, who's with Josh Nicky Municipal Office, wrote the thing, because we're not questioning the zoning on the 3 units, we're just literally doing an extension, so it would have been a rear, and first and second floor addition, because of the 3 unit, the intention is to maintain that completely.
And the sign posting didn't reflect density. The sign posting was for a permit to demo existing rear addition and construct a new 2-story rear addition. It doesn't mention whether single family or multifamily.
Well, I think his point is that
That wasn't an issue.
Yeah, I realize that.
Yeah.
And the city records do have some history of multifamily use for 3 dwelling units. It
And
just wasn't a part of our analysis.
Right, and it was reapproved on Monday. Oh, gosh, that would have been the 12th. I have a new multifamily license for that, in its current condition, which is honestly deplorable. So my goal is to really rebuild it and make it a lot nicer.
Okay, any questions? All right.
I also have that I'd like to put in the file. This is neighbors all along Chestnut, 33, 3400, and into the 3500 block, so those directly affected. And property owners, as you'll see, some of the lines are people that own multiple properties that reviewed my plans and also signed and gave their phone numbers in support of the additions and what I'm trying to do on these properties.
Okay. All right. Why don't you step aside for a
Sure.
moment? And folks, you'll come up. Those microphones do like
Work
to
for
bend
short
them
people?
down, so yes.
But anyway.
Well, I didn't want to say that. All right. Who's going first?
Go ahead.
Well,
if you can just state your name for the record again, sir.
my name is Lawrence Wixulis. I live at 3451 Chestnut Avenue. Let's see, where do I start? First of all, the legend for 47 is incorrect. For the second floor addition, the lines go in the wrong direction. So any persons who signed the petition, we're looking at an incorrect, what's the key? It's on the legend. The legend's incorrect. Second of all, the 2 houses that he just purchased are from a landlord that owns many, 30, 40, 50 houses in the neighborhood. And some of those signatures are possibly from tenants of his who so these, if they're not homeowners, if they're renters, and they're renters from the people he's purchasing the building from, that's relevant. So I just want to address that. I purchased my house in 2006. I did, it was attracted to me because of the light of the breezeway that comes in, because of every room I have natural light. I did a historic renovation of the house because I appreciate their 1880 row homes. You know, they're not much, but single family like mine and the other ones are in the block, they're plenty for single family, 2-bedroom, 3-bedroom. So the character of the properties all fell in line pretty much. There are some people who did illegal renovations back when they got away with it, but present day, objections and people who try to protect their people who may be more inclined to actually object, to, especially when people do things without permits back in years past. So I purchased my house, accepting what it is, accepting it's 1880 row home with nice light breezeway. I literally, I could show you pictures of the light that I have that come into my house from the windows. I have 5 windows that, my biggest objection is he's going to take away the breezeway on his side. I think I have him, he corrected me in the hallway. I think I have a misinterpretation of the phrase breezeway. I think breezeway is the tunnel, but we both have those little alleyways or whatever we're going to call it, 3-foot set space on each side. He has 3 feet over there, I have 3 feet on my space. But he's going to take that away, which is going to close that gap from a 6-foot gap to a 3-foot gap. That's going to close down the shaft and have more of a shaft effect with less light coming in. I don't know if it's submittable, but I can show you how. This is the chair that I sit in and read. This is the light that comes in. This direct sunlight comes in. That's actually a magazine on my lap with direct sunlight coming in. This is here where the second floor is going to go out, and I don't even know if I have an objection to this legally, but the second floor is going to go out to meet the first floor. It's an extra 30-something feet that second floor is going to go out, so I'm going to lose that sky. Also, I hate to do it. I don't ever play this card, but I'm handicapped. I have one good eye. So the natural light is great for me. The fluorescent light and some of the lights are harder to read by. I sit there. I'm not a great reader, but when I do read, I use this light. And I use it upstairs in my office, the second bed. I don't have pictures of it. The second bedroom has that natural light from the same exact position as window, just on the second floor. So, the square footage apparently tearing down the garages is what's going to help give him the. These are what we're talking about with garages. I mean, these things are just sheds. Now, I don't know. Maybe tearing them down is going to gain him the extra square footage legally to increase that and take away the breezeway, or I say breezeway, I'm sorry, I use the wrong terminology. Take away that 3-foot section, but these are, I'm not an attorney, but maybe these are not livable space, and maybe, I knew they're not livable space, of course, but if that allows him to add livable space to that building, then that's the way it goes, I suppose. But also, also the fact that it just got approved. It's functioning as a 3-unit, as crappy as it may be. Okay, it's our blue-collar workers over the 140 years it's been there. It just got approved, they said, on Monday for 3 apartments. So I don't have a problem with people making money. I'm a capitalist. I don't have a problem with him making money. But to augment it from the 1880 traditional kind of house it is now, to augment it to where I'm going to lose the light and air, my neighbors are going to lose light, because it's southerly exposure sun also, which is important because of the warmth of the wintertime light coming in those windows. So I'm going to lose warmth, I'm going to use the warmth of the sun, I'm going to lose the air, and I'm going to lose the light. Being with my handicap, it's relevant. But to add, if it's already approved, and just got approved again on Monday, as I said, to change it to such a degree and add such the amount of square footage and to augment it and take away all that light and air issues from me, it's just a monetary issue. It's not, it's about maximizing value for the developer. It's not about, and I normally I don't have a problem with it, but it's going to affect me directly. I'm not going to, the historical nature, even the one next to her, the historical nature of the houses are going to be changed drastically. So we can have this McMansion to where, since we have 150 square foot, and people start tearing down little ratty shacks like this and then gaining that square footage and adding to the house, and next thing you know, you're going to have people like her. She's going to have a real problem. She's going to have tunnel vision where her house is set in. There's going to be 2 big, long houses on each side. I mean, where does it end? I mean, if you can if you can tear that down and gain square footage and affect other people's lives so much and change the historical nature of the houses, if it's legal, it's legal, and there's nothing I can do about it. I'm just here to say that, for whatever it's worth, it's going to affect me personally, and I don't have. I actually have something to gain because I'm a licensed real estate agent. Not very good at it, but I referred him to 3 other homeowners on the block, or a guy who owns 3 other homes for sale. I could potentially lose if he buys them. I could potentially lose a commission, because the guy I referred him to said he would put me down as a listing agent if he sold them to him. So I've got to worry about a lot of things because there are things like, it's a single course brick wall in between our houses. So when that construction goes on, we're going to have issues. This is my house. That's his house, so when this comes off, this is gonna have to be repaired on my side. I've literally taken this fence I had built, and it's right to the border. I'm sure I'm on my side. And that's my windowsill, and that's where my fence is. Also, this, sorry, I should have wrote a script, but I'm nervous. But
I was gonna say,
this 44.
stop for a minute and take a deep breath.
Yeah.
I promise, we won't bring out the rat.
Bring out the rat. But this is just to show you, that's the end of the existing building. He's gonna tear all this down and then rebuild the second floor all the way out to that point. So I'm gonna lose all that space there too. And that's southerly exposure sun and warmth, grass dying, whatever. Also, this space, well, when you look at this area, this is I'm always alleyway. I won't say breezeway because apparently that's the wrong terminology. But this is that space that in 1880 built these houses deliberately like this because there were no lights in there. You needed natural light. There was gas lights in the house. So this is the area that he's going to develop now that's now not, that's open, and that helps me get light. But there's 44 feet between start of the breezeway to the end, 44 feet that I'm gonna have a fence that I paid for and had built, and he's gonna bring it up to however 8-10 inches his development, or right next to it. So it's gonna be on his side of the fence. It'll be unmaintainable though. I'm gonna have a fence line that's I don't even know if I have an argument there. I just wanna bring it up. I don't know if it's even a relevant point, but it's gonna be an unmaintainable space. From what maybe I used the wrong terminology when I talked to Mr. French. I don't know, is Mr. French here from planning? Mr. French? Oh, he's Mr. French. Oh, yeah. And I might have used the term breezeway, but he had told me that when you want to increase the actual footprint, then that's a variance issue. Because now, what he just told me in the hallway was that the fact that he's taking down those sheds, he can go back what do you want, the 75 feet? Or minus 7 feet off of that, or 7.5 feet. So I don't know if I just used the wrong terminology that it got that reply from Mr. French, but if it's a variance, my point is it's perfectly functional as of even Monday. The city okayed it for what it is right now. The only reason to change it, to augment it right now, is just to get the maximum amount of dollar out of the house. And I don't have a problem with it making money. That's the weird thing. I just don't want it to affect me to the degree it is.
Okay.
Sorry, that's it.
Ma'am?
Okay, my name's Rena Abrams. I'm at 3445 Chestnut Avenue, so I'm more concerned with the 3447, but also agree with Larry about, opposing the 3449. Basically for the same reasons. So for me, my house is 42 feet long, so, he's talking about basically building a wall, up in my yard about an extra 35 feet. I did my math right, which is really significant. So I'm going to be looking at a wall. And not only is that impacting me, someone that likes to spend time outside of my yard, part of the reason I bought a house in Hamden, but also when I go to sell the house, yes, it's going to be increasing the value because he's renovating houses on the block, which I am 100% for, but the longer that house extends out, the more it's going to impact me, and like I said, my resale value of it. The natural light, 100% agree. We talked about when we were in the hallway that, all these row homes have windows on the front and the back. So when you're taking any of that light away, it's really impacting, any natural light that we're getting in our homes. Those are, like I said, I think we've kind of talked about all the reasons already, and I don't think I have a whole lot to add except that, that other property is what's really impacting me. And I also agree, one of the things about those signatures is not only are those people not property owners, but even if they are property owners, it's helping them, but they're not directly next to these properties that are being extended out. And I think we're the, main people that are really being impacted by them. I don't know if additional photos would be helpful for you to see what we're talking about. This is the backside of, this is 3447, and this is 49 that extends out. So he's talking about extending, the second level up here on this side, and then both of these levels. This is just an image. So this is from my yard. I have my deck here, and then that pole is how far the wall would be going out, so it's, you know, again, really extending back, and my deck is, I should have measured it, but probably about 15 feet, you know, going this direction, so, really significant. So, I mean, and then this is the, whatever area you wanna call it, where, you know, this is my side, where if he's pulling this part in, we're gonna have a much smaller space in that area. So I think that's, like I said.
All right, I'm going to pass those up. For the record.
Would you like my pictures?
Yes. Sure.
My company charged me 30 cents per copy, but they're going
All right. Thank you both.
Thank
you.
Mr. Carmichael?
So may I see one of the pictures that they handed up, because I wanted to comment on one of the things. I
Well,
apologize.
I want to really sort of push all that to the side
no, I
and jump
just-
to the chase. No,
Okay, sorry, sir. Sorry, I apologize.
I want to jump to the chase here.
Okay.
Your existing structure covers about 30% of the lot.
Correct.
The maximum allowable lot coverage for where you are is 45%. You want to go out to 72%. So you need a variance to do that. Now, when you say, well, you know, I need a variance for that, it's not just, well, you know, you get a variance because you want to say that you want a variance.
No, I totally understand that.
You
and I
need
support the
to
process.
have a reason for why you're seeking one. And the code and the law for variances is fairly restrictive. Some might say overly so, but regardless, the point is that there are a number of hoops through which you need to jump, but yet you have not yet even attempted. And one of the primary showings that you need to make in order to obtain a variance is you need to show that the property is somehow unique, and that you will suffer some kind of a hardship or practical difficulty if you don't, if the full limits of the law are adhered to, and that hardship or practical difficulty has to be one which is imposed by the code, and as opposed to things outside of the code. And one of the biggest things I think, frankly, of at this point is that the reason you're seeking a variance can't be solely or primarily for monetary benefit. And during your direct, you said that it was. So
I said to maximize the value of the property.
that's right.
You know.
That's monetary
Well,
value.
And the reason that I was asking for the picture, Mr. Chairperson, is because the current 3-unit layout that was approved, they enter through a garbage alley and then they go onto the neighboring property
So
to
what?
go up.
So what? The property's been rented for years. People have been entering and exiting that way for years.
But-
The point is
So-
that
sorry.
is that the property can be utilized in the way that it has been utilized, even without it. And even you could have some variance, something less than 72%, but something all the way up
It's
to.
not 72% lot coverage. I apologize, sir. It's
Our numbers say 72% lot coverage with respect to appeal number 47, and also to appeal number 49.
It would be 50% because we're demolishing the garages.
I don't really think that really gets figured into it, but regardless, the point is that that in order that your limitation is 45%, if you want to vary that limitation, you have to satisfy the requirements that are set forth under the code. Okay, so why don't we start there, and you can tell me why you satisfy what's required in the code.
So
Start with how the property is unique.
the property is unique because 34, 47, and 49 were owned by the same gentleman for over 70 years. His father, and they had a grocery store on the first floor and then apartments in the back. Because they owned both properties, they made the entrance to 3449, the one unit on the first floor and the unit on the second floor, enter through the back. In order to enter 3449, you must cross over to 47's property, go up a staircase that's located on 3447, and then cross back over to 49.
That's only if you use it, if you continue to use it as 3 dwelling units. If you operate it as a single-family dwelling, you just enter into the front, just like whoever that front unit, that's how they presumably go in and out. Everyone doesn't go in and out to the back.
Sure.
And you could even change the layout of the apartment so that such that you could have entrances to the fronts of both units, to the front of both the front of the house, without having.
With the existing width, that would be very challenging to make an entrance to 3 units, on the back side of the property, it being almost only about 10 feet wide. So that's why we're seeking that, and the entrance on the second story there. We are intending to keep it as 3 units, but to take the property on 3447 and resell that later on down the road as a renovated property. So I very seriously doubt that somebody's going to be okay with people entering their property in order to get to a multi-unit on 3449, because that's the only way to access the 2 rear units.
You had said earlier that you received approval for multifamily in that property.
Not
Was
me
that through
personally. It was the-
property registration, or was that through zoning?
No, that was actually inspected by Baltimore City. It was the previous owner gave this me.
Property registration or for zoning purposes?
Both. He has a multifamily
So-
license and a registration on
I
it.
think what you're talking about is a multifamily license.
Correct.
Yes.
Because
And
when I look at the requirements for 3 dwelling units,
Mhm.
if you were to put 3 new dwelling units there, you would need over a 50% density variance for that property.
But they're not 3 new dwelling units because currently,
Okay.
yeah.
Is the property currently vacant?
The property is currently vacant.
How long has it been vacant?
Since the day after settlement,
Which was when?
August 15th.
Before that, was it rented as 3 dwelling units?
Correct.
Okay. It's just, I'm stuck on this single-family, multifamily thing, because
Sure.
if this came through as multifamily, we would flag that.
Okay.
Because a near 50% variance for density in that neighborhood is a big deal.
Okay.
And it's possible that you could have received a zoning approval for 3 dwelling units is entirely separate from property registration.
Sure.
Property registration is about taxes and fee collection,
Sure.
to be very honest, and safety. Zoning is a whole separate animal. And I'm stuck on that single-family, multifamily thing for that reason. So moving forward, you would still need to get approval for 3 dwelling units from zoning
Correct.
for that use.
Yeah.
And again, I stress the fact that if we had known that when this appeal came in, we would have flagged it and put it in our staff report.
So I reviewed this with my title attorney, I reviewed this with my engineer, and they both confirmed that it was already zoned 3 units. We weren't changing any of the use, we weren't adding any units. We're actually, where the garages are right now, they're unusable parking space. We're tearing down those garages and allowing the new tenants will be able to park in there. So my engineer and my attorney felt that there was no reason, like, the clerical error, definitely putting it as single family, that was just something that I'll have to talk to Josh Nicodemus about. Who's very, done a lot of work in this board. But we're not changing anything as to what it was already zoned as and licensed for. So, and then in terms of what we see, there are no basements on this property, whereas the majority of Hamden, they do have basements, but they're just like 3 to 4 feet tall and have a lot of challenges with them. In a normal property of this size, I would do an underpinning permit, dig out the basement, finish it off, because that's what the market is looking for in these properties these days. But we have no ability to do that. As down Chestnut, there's almost a spring that goes down, as many of the neighbors have told me. And it's unfeasible to finish out a basement there. So in order to build the property as what the current demands are, I really do need to get 3 bedrooms upstairs, because that's what most of the consumers have been asking me for. And there's a lot of properties on that block that have already been extended, if that, what I'm asking for, if not more.
Do neither property, does neither property have a basement, or just
No,
a
they
47?
they both have basements
But
per
not
se,
usable.
but not usable. The one at 3449, when the last I went in there on August 15th, had 3 feet of water in the basement, So we're going to be rectifying that very soon. So, and the comment to the owners and the neighbors there, I had owners sign on there. I had everybody that I knocked on the door that answered. I can't speak to whether they're owners or neighbors. I do know a majority of them are owners because I talked with them about that. Also have an owner who owns about 5.
I'll just point out that for as far as approval standards for variances, whether the neighbors do or don't object, sort of, again, it's not something that's put to a vote.
Sure.
So it's something that's nice to know, but frankly, it doesn't make a difference.
No, I understand that, sir, and I appreciate,
And that goes for either side.
yeah. And we, the simple fact is that for 3449, with the entrances being in the back for the two back units and the foundation being completely obliterated, I mean, you can't walk in 3449 without seeing ruffles in the carpet, and that's on concrete, slab. It needs to be rebuilt in order to get the most effective layout so that everybody can enter through the front in there and not enter through the neighbor's property. I would need to do that extension on 3449. On 47, if I'm going to be pouring footers at the same time, rather than pouring two separate footers, I would do just footers all at the same time for 47 and 49, and create the best layout of a property, considering what's available on the property.
All right, any questions?
No.
All right. Thank you
Okay.
very much.
Thank you very much, and pleasure having you on the board. Thank you, sir.
Thank you. Take care. All right, 2018-259, 4018 Edmondson Avenue, Yvonne Turner.
Good afternoon, panel. I am Yvonne Turner,
Okay,
and I wish to postpone.
okay.
um,
All right, you had some folks who were in opposition. Everybody's on the same page as far as the request for postponement?
Yes.
Okay. Okay, 2018-259, 4018 Edmondson Avenue is postponed.
Okay.
All right, and to get back on the docket, all you need to do, do you have a card, Derek?
Yep.
Okay. Just call into the zoning board office. You can contact Mr. Baumgartner at that number, and they will get you back on the schedule. Okay, all right. Thank you all. Thank you folks all very much. And 2018-261, 3364 Wilkins Avenue, Andre Jones. So, hey folks, thanks for being so patient. All right, you're Mr. Jones?
Yes.
Okay. Mr. Jones, we have this as an application to use the first floor as a convenience store at this location. Is that correct?
Yes, correct.
Folks, if all those intending to give testimony in this matter would please raise their right hands to be sworn.
You swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. Do we have staff reports?
Yes, we have two letters from residents, 3404, and someone from Pizza Land. Okay. They both write, the size of the store, they're against it. The size of the store is so small, it hardly lends any credible space to operate a functional convenience or grocery store. They also write that when a convenience store opens, it brings a lot of problems and illegal activities to the neighborhood. People start standing outside of the store and throwing trash all over the place. It hurts the privacy of the residents. The stores usually revert to selling tobacco, loose cigarettes, and the illegal activity of cash for EPT cards. The neighborhood will definitely end up in a filthier, dirtier mess. That is the end of what I have.
Planning Department reviewed this application, noted that it specifically states that there would be an outdoor seating area provided in the front of the property, basically what amounts to the front yard of the property. The request is for a neighborhood commercial establishment, and the zoning code limits, as we've heard discussed in the previous case, business use to inside the building. Therefore, the department considers the use of the exterior for a seating area or eating area as not approvable. The Department of Planning would recommend approval of this application, subject to the condition that there is no exterior seating or eating facility provided in the front yard of the property, and subject to all signage being approved by the Department of Planning. Thank you.
Thank you. Okay, Mr. Jones. Are you willing to agree to the conditions that are offered by the Department of Planning?
Yes, yes, sir.
Okay, all right, so that would mean that you wouldn't be able to have the outdoor seating area and that use?
Yes, we understand that.
Okay.
When we first came to the neighborhood, we discussed with a few residents there that we didn't talk to everyone. I don't know if we talked to enough, but we talked to a lot of people. And I think we talked to this gentleman here, now that I see him up close. He had suggested even hot dogs to sell. But, you know, what it is, what it is. What we're trying to do basically is bring an old school, old style feel to the neighborhood. It's called the nickel box for a reason. Remember the old 5 and dime? That's what we're trying to bring back. You come in with $1, $5, you come out with change, and you're happy. And that's what we're trying to bring. Everything is an old school feel from the, we're not looking to have hangouts or anything like that. There's a 7-Eleven like 2 blocks up the street that the prices are really high. There's not rich people that live in the neighborhood, and they're looking for better prices. Yes, the store is small, and that's what we expect to do, have it small and convenient for the neighborhood.
Okay. So you're, I guess, planning on offering snacks, drinks, et cetera?
Correct. Also, other conveniences such as bread and things of that nature that people need for their household.
Staples, that kind of stuff.
Correct.
All right. All right. Any questions?
No.
Okay. Sir, if you can state your name, please.
My name is William Cromer. I'm the next door neighbor.
You said Cromer?
Yes, Cromer. I live 3362 Wilkins Avenue.
Okay. Can you spell your last name, sir?
Cromer.
All right. And, sir, where are you with respect to this appeal?
Sir?
What's your position on this appeal?
Well, there was a Jamaican store next door, and they ate outside. They tossed trash in the yard. They have a number of young children around, and then in my house, I'm retired. I hear the MFs and the profanity and everything, and I think it's going to be the same thing. They got 7-Eleven down a block and a half. They got another convenience store, another half a block at the gas station, and I don't think the neighborhood rates it.
Okay. So you wouldn't be for it even if they took out the outdoor seating and all
The
that?
building, the front room, I used to own the building. The building in the front room is only about a 12 by 10 or 12 by 11. I just don't think the neighborhood should have one with the young children and everything hanging out there.
Mr. Cromer, was this property formerly used as a coffee shop with accessory outdoor table service?
No, it was a Jamaican. He cooked chicken outside, which he shouldn't have, and I couldn't open the windows for 5 years. And it just, and I think I don't think it's feasible. I mean, I don't have the power to say that, but with the 7-Eleven down there, and they have another convenience store at the gas station, another half a block.
The only reason I ask is that there was a prior appeal from 2005, and the applicant was a Brian Cromer. I wasn't sure.
My son.
Okay. And that was to use the property as a coffee shop with accessory outdoor table
Yeah.
service. So I just wasn't sure if that actually kind of got off the ground or not.
Yes. I gave the building to my son. He had the building, and he sold it.
Okay. Anything further? Anything more?
No, sir.
All right. Ms. Jones, you get the last word.
Excuse me?
You get the last word.
There's really nothing to say except we're not having outside seating. We never planned on it. This is the Wilkins Avenue convenience store as we had it.
I got the same thing.
We have it. So we never thought about doing anything like that. Like I said, we spoke with the gentleman before. He suggested hot dogs. We heard about the Jamaican place. Yeah, we heard about the Jamaican place, and we never been there or visited there before.
That's fine.
So
What
we
about
don't
the
have anything
point
to do
that
with that.
the space as it looks, there's not, measurements or whatever, but I can tell from the second drawing that it looks like the space is about 13 feet wide. And the portion looks like it's maybe about 20 feet deep with the,
Do I have the dimensions on there?
yeah. Yeah, that's what I said. It's about 13 and a half feet wide and about 19 feet deep. Of that 19 feet, there's a sales counter that's in the middle of it, cutting it roughly in half. So maybe 12 feet is kind of is sort of the customer space. It's a really small space. Is that, is a store really feasible in this location? I mean, sufficient to support, the rent? You've only got about 12 feet by 13 and a half feet of space available for retail. I do see that there's going to be cigarettes behind the sales counter. And the rest, it's going to be just snacks and waters and sodas.
Correct. And well, that's a rough estimate. I think it is where the counter space is at. We was planning on moving it back and having about at least 4 feet behind the counter where we can operate, and the rest is for the customers. Now, as far as everything else goes, it's just when we first started, we couldn't get nowhere. We couldn't go anywhere. Nobody would accept us unless we had it. We had $75,000. We don't have that kind of money. But we wanted to bring something nice to our neighborhood, and we couldn't. Everything was occupied. Nobody would accept us. We wanted to bring good service, something that we don't get often. And so we wanted a neighborhood that was residential mostly. We even spoke with the chocolate factory down the street. There's a candy factory down the street, like 3 doors down. I think it's right next door to the gentleman here. We spoke with them, other neighbors. They approve of it. They like the way it sounds. We didn't know anything about having letters. We're new to this. We're very new to this, but we know how to offer good service and how to be friendly to people and give what they need, because we have those needs also.
Okay. All right. Any questions?
No.
All right. Thank you, gentlemen.
Thank you.
Thank you.
Take care. All right. And we are done.
They're going to.
All right. Okay, which ones do we want to talk about?